Welcome back. The housing needs of thousands of landless people outweigh the rights of a private company. Therefore, the state may expropriate property worth 30 million rand without compensation. This was argued by the Ekurhuleni Metro in a case over the expropriation of a 34-hectare piece of land in Driefontein, Boksburg. The case could become a test of the state's ability to expropriate land in the public interest without compensation. For more, we are joined by Dr. Gaopalelwe Mathiba, who is a senior UCT lecturer at the Department of Private Law. Dr. Mathiba, thank you so much for joining us and a very good evening to you. Now, let's just go back to basics here. What does current legislation say about expropriation without compensation, if and when it can be done, and how?
No, thank you so much for having me, and good evening to your viewers at home. I think I must start by indicating that, indeed, this is an important case that should be of interest to everyone, especially the homeless and the landless. It is a unique opportunity for our courts to test out the bounds and limits of the nil compensation concept in the South African expropriation law, which is a development that has been met with quite mixed reactions, not only locally, but across the world. In my considered view, I think it actually makes a very good case in point in which the public interest imperative, in the form of course, the state having to source out land for low-cost housing, could override the interest of a private landowner, like you correctly said in your introductory remarks. So, with Driefontein in particular, what we need to know is that the process to expropriate the portion, this 33-hectare piece of land here, started actually in 2018, but then the city then actually get to finally expropriate. In 2018, it served the notice, and then 2019, it finalized expropriation of the plot. And of course, it had to do so in terms of Expropriation Act of 1975. That is the old Expropriation Act. And I think I must indicate that quite from the outset that this matter will be adjudicated on the basis of that old Expropriation Act and not the controversial new Expropriation Act of 2024. And that is, of course, what I must outline. And it is important to also note that in the old Expropriation Act of 1975, the nil compensation provision is not there. The nil compensation provision is only in the new Act, the 2024 Act, which, though it has been assented to or passed by Parliament and signed by the President to become the law, it has not yet taken effect. Hence, this matter cannot be resolved using it or on its basis. So it might be a little bit opportunistic for the city of Ekurhuleni to try and rely on the act that has not yet taken effect on the basis of nil compensation, because of course you can't do that. The process was started with relying on an old Expropriation Act. And you must also remember, quite an important other aspect to this is that this test case of expropriation, as people keep saying, it took place during the 2018-2019 period. And you would remember that it was during that time when attempts were made to amend Section 25 of the Constitution to explicitly provide for expropriation without compensation. However, those attempts failed, and hence we are where we are today. But then there's a very strong and compelling case for the city of Ekurhuleni. What makes this case compelling? At least at least three facts can be observed here. One is that the Driefontein farm, throughout all these years, I will provide the history to this plot of land later on. Throughout all these years of the existence of this plot, the plot has remained vacant and with no sign of intended occupation by those that claim ownership of it, wrongly or rightfully. hence the allegation that the owner, which is the current owner, which is Business Venture Investment, is holding the land for speculative reasons. And the second strong hold for Ekurhuleni is that there has been no active land use on this land, except for mine dump use in the 1880s, as I will show earlier when I just briefly share with you the history of this plot of land in terms of land ownership. There's never been active land use on it. And lastly, there has been no active property transaction on open market over the last at least 100 years or even more in respect of this particular piece of land. There's never been transacted through an open market, which is required, of course, by the 1975 Expropriation Act, in terms of which this matter is being canvassed or ventilated. And Ekurhuleni Metro would have an argument saying that the owners of this land, whoever who has owned it, previously, even currently, they would need to contend with these realities that their property rights are not absolute. Under certain circumstances, in the interest of public interest and also for public purposes, the non-owners' rights can actually get to trump over their private property rights.
And also basing it off what you've just mentioned now, that those things that were flagged by the City of Ekurhuleni to say the property hasn't been leased, it hasn't had any tenants in the past 30 years, it hasn't had any improvements done. And also according to the city, they are arguing that it is not in the public interest to pay the compensation, as the housing needs of the thousands of landless residents outweigh the private company interest, because clearly there hasn't been any activity on that property. However, would you say that argument will hold in your legal opinion, considering that the city itself valued that property at just over 24 million rand to 30 million rand?
Yes, no, that's a good question. So understandably, Ekurhuleni Metro is responsible for meeting the needs of its local citizens, the housing needs of its local citizens within their area of jurisdiction. There are nearly 500,000 people on the housing backlog. I mean, everyone in the world knows that South Africa is battling a terrific, unprecedented statistics when it comes to homelessness or people who are homeless. And this number keeps growing. And quite a number of factors actually exacerbate or cause this number to spike in a fast-track pace as it does. Through evictions, people get to be evicted. We see through medias all the time there's eviction cases ongoing. So evictions from elsewhere, but not only through evictions, but also through urban migration from rural areas, people moving from the rural areas flocking into the cities, especially the key metros, Cape Town, Durban, Ekurhuleni, Tshwane, Joburg. And that is where we actually today then have to sit with this quite a stark conflicting interest. And you really need a sober system to try and struck a very delicate and fair balance between these two competing interests. You would know that oftentimes there's this culture of lack of things that we always get, or it always have to be pulled whenever there's failure in delivery, especially when it comes to housing. The city or the metro, and this is not only Ekurhuleni now, I'm talking more generally, it's either you're going to be told by the metro that no, we cannot meet the housing demand in our metro because the city simply does not have a well-located land through which to build or to roll out low-cost housing. And then in the absence, if it is not the land, adequate or well-located land being there, is resources. The city would complain that it doesn't have resources and the budget to roll out sufficient amount of low-cost housing to meet the demand. So Ekurhuleni, I would say, it is well within its right to try and to test out the expropriation without compensation argument. And I think the reason that it is canvassing, which is of course to roll out low-cost housing, is much more compelling to can actually justify their decision to expropriate this. So I can actually just give you a bit of like historical background to land holding or ownership of this property, if you wish.
Sure, Dr. Mathiba, you can do so briefly. Give us that brief background.
Oh, okay. So the Driefontein farm, it's a 33-hectare piece of land in Boksburg, in Ekurhuleni. The farm has never been an object of any traceable transaction in the open market by a willing seller, in which a market price for the property was determined and paid by a willing buyer, as of course required by the 1975, the old Expropriation Act. And this is seemingly a key argument that Ekurhuleni Metro relies on in its justification for its decision to expropriate this property. Like it is the case with many tracts of land in rural areas, the Driefontein farm was demarcated during the 1880s. And we know during that time, Gauteng was experiencing what we know to have been called the gold rush. And it was established as a farm under the name of a certain gentleman. How and for what reason it was established under his name, the question still to be answered. I hope that part of the discussions that will happen, the arguments and the claims that will be tested through the upcoming or the anticipated litigation on this matter will actually get to answer those questions. Then in 1887, this gentleman transferred this portion of land to the Witwatersrand Gold Mining Company through what we call cession, which means the land was not sold where a market price was paid in an open market. The mining company then held the plot for over 100 years, using it as a mine dump until around 1997. And in 1997, the plot was then transferred, again, not through an open market transaction, I must remind, to a company that happened to be a subsidiary to the Witwatersrand Gold Mining Company. As at the time, it was part of a big transaction involving so many properties that were registered and held in the name of this company across the country. And then again and again, the farm was transferred in 2005, 2006, 2005 to a new company, but this company was yet another a subsidiary to the Witwatersrand Mining Company. So we can see a direct line that this property, this farm, it has always been held by a single mining company and its subsidiaries, at least since 1887. And then, in fact, the last transaction that we could trace on this property is set to have occurred in 2005 for 1 million rand. And it was actually selling from one company to its own subsidiary that was created just for that purpose. But so the owner is wanting 30 million rand in compensation because they are saying it could be developed for other
Dr. Mathiba, just to interject there, even then, that 1 million rand transaction, the only one that you can find, was that even at market value?
No, it wasn't, because I think you can see the stark difference in terms of that last transacted amount of 1 million in 2005 to 30 million currently, as the owner is currently seeking. 30 million is actually even the entry point to what this property is set to be valued at, because I have seen some reporting by Sheikh Liga saying that the property can be valued anywhere between 30 million and 60 million, which is quite high. So one can clearly see that even the last traceable transaction on this property back to 2005, it was not even a market value. It was not even a market price for that matter. It was just one company basically playing around with the plot of land across its different subsidiaries. For what reason? That, of course, is again another question to be answered. Yeah. So what we're saying is that the company is wanting 30 million rand in compensation, as we know, because they are saying the plot could be developed for other purposes. They could get it rezoned, so they argue or they claim.
But they never
so
did
they are
for
making
30
a claim
years.
based on what could be, what they anticipate, which means they are holding the plot speculatively.
Yeah.
And of course, I don't even want to cast the prospects of success on a case that is based on a speculative reason. And like I said earlier, for reasons that I mentioned, I think Ekurhuleni stands a very strong and compelling case here on the basis of its constitutional mandate. I must emphasize, to make housing, low-cost housing, available to its local residents. There was an argument made by the owner of this plot of land that by the time the city finished it with a notice of expropriation, there was actually an intended development that I think they say something like they were awaiting the approvals to get the plot rezoned for their intended development, the same development that today, on their claim for 30 million rand or more of compensation, they are forgetting to even self-correct to say that we're not speaking of this on speculative grounds, but we're speaking of this as we have done a scoping study on it, and we have actually had a full-blown proposal in terms of the township, the development that was going to be rolled out in this piece of land. This is how much that development was actually quantified or estimated to be worthy of or to be valued at, and so like that. All that is doing, it says that now we can get this land rezoned, we can turn it into some we can use it, give it a different usage and develop it in a way that we may deem fit, as long as we get to secure the necessary approvals from the very same Ekurhuleni that is giving them a tailspin.
Yeah. Dr. Mathiba, I really appreciate your time and also giving us that background and the history on that property as well. Really appreciate those insights.